Pump it up. You got to pump it up. You got to know. Hey guys, what is up? It's Dusty here, and welcome back to another episode of the Daily Crypto News. And today, we get ourselves a juicy update on the Ripple v SEC lawsuit. This video is specifically for XRP holders, as if you're not holding XRP and you don't care about the lawsuit, then yeah, this is not the update for you, my friend. Having said that, we get ourselves some juicy news today because we got ourselves a breaking news update. The court has denied the SEC's motion for reconsideration of the DPP ruling and granted the SEC's request for clarification of that ruling. This is juicy because if you guys don't remember, the reconsideration, what that was all about was basically, hey, there's these William Hinman emails, right? And there's this information within the SEC, basically. We, SEC side, don't want Ripple to see that. So judge, whatever decision you made, reconsider it. We'll give you an additional bunch of documents to overlook to really make sure you understand why we cannot give this to Ripple or why we shouldn't. That's basically what happened. That's basically what they did. And now the judge said, we're not going to do it, but you guys hopefully know what I meant with that. Of just, no. We reconsidered it, but we ain't going to rule by your favor, basically. We didn't actually reconsider it fully. It was basically just like, yeah, we're not going to reconsider it, I guess, because it just doesn't make sense. Having said that, the reason it's so important is because this was mostly as a backup for the SEC. They were just like, okay, we didn't win it this time, let's try it again. But Ripple saw it as a, let them reconsider or try to reconsider every single part along the way, because if they do it, it's going to be way harder to appeal the decision after it's been made by the judge. And what I'm talking about here is, let's say XRP does not turn out to be a security in the end, which we all suspect is going to get towards. Then the SEC can still always say, let's take this a court higher, let's do this again, because we don't think this judge made the right decision. Let's try this whole trial again. Now, the more you've reconsidered every step, the more people that looked at every decision that was made before, the less susceptible to mistakes it basically is, so the harder it gets to appeal certain decisions that have already been double checked in the past before as well. So from Ripple's side, they were saying like, well, we don't really mind them looking at everything because we do still think that we'll win anyway. So it's better to double check everything now, knowing that we'll win, than letting them have the option to review everything afterwards when it's going to be a little bit more uncertain, I would say. So that was the very big update from today. Again, decision officially was the title. Decision denying reconsideration of the DPP ruling and granting the SEC's request for clarification of that specific ruling. So they're also making it a little bit more clear, okay, as to exactly what that means. By letter motion, the SEC moves for partial, this was before, right? Opinion and order, Ripple Labs against, or defendants, SEC plaintiff against Ripple Labs, Sarah Netburn order. Let's see, how many pages is this actually? 11. By letter motion, the Securities and Exchange Commission moves for a partial reconsideration or clarification of the court's January 13th order, which held in relevant part that emails concerning concerning and draft versions of a June 14th, 2018 speech given by then Director of Financial Director of Corporation Finance, there we go, William Hinman, are not shielded by the deliberative process privilege. The motion is denied as to reconsideration and granted as to clarification. Okay, fair enough. Okay, so after reading through it for a little bit, of course I have to do that myself every time as well, if you guys didn't know. The first part here is just talking about what exactly happened, what the cause of all this was. A little bit further in, exactly right here, they talk about how heavy a reconsideration is. Reconsideration of a previous order by the court is an extraordinary remedy to be employed sparingly in the interest of finality and conservation of scarce judicial resources. Again, the first part here is just kind of explaining why this needed to happen. The court assumes the parties' familiarity with the facts. SEC brings the action under Section 5 of the Securities Act, alleging that defendants are currently engaging in the unlawful sale of securities, and that the founders aided and abetted Ripple's violations. As relevant here, defendants sought certain documents from the SEC to challenge the SEC's allegations that Larson and Garlinghouse were objectively reckless in believing that XRP was not a security, and that Ripple was on fair notice that XP was security. Following the court's ruling on the relevance of certain categories of documents, the SEC searched its files and raised objections to the production of certain challenged documents on the grounds that they are protected by the DPP. The court conducted an in-camera review of exemplar documents identified in Appendix A to defendant's motion. Based on its review of the documents, the court granted defendant's motion to compel production as to certain parts of Entry 1 of Appendix A, and the SEC now asked the court to reconsider its ruling on, or as to this Entry 9, or in the alternative to clarify whether the court's January 13th order compels production of all emails related to and drafts of the speech on the SEC's privilege log. In support of its motion, the SEC has submitted another 10 documents for in-camera review. And again, if you want to know what this specific part is about, let's go over here. The speech purpose, this one is a little slippery slope. SEC's assertion that the speech was intended to communicate Corporation Finance's approach to regulating digital asset offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal views. So here we're also kind of starting to see it already. We don't really know if William Hinman's speech was an opinion or trying to help out for the commission or what exactly it was supposed to do. See motion to quash the subpoena. Director Hinman made a public speech on June 14th in which he expressed his own views, yada, yada, yada. Just we all get that part, right? We don't need to go too deep into all of this. Then, again, the SEC tried to take a different view, and even on the merits, the SEC's new position is not justified, where basically the court disagrees with the SEC that the text of the speech shows Hinman's intent to provide a framework for Corporation Finance's approach to evaluating digital asset offerings, saying that SEC staff are happy to help promoters and their counsel work through these issues. Point being, it's very hard to see whether or not they're now trying to go into a new caveat or a new process of saying Hinman's speech was for the Corporation Finance Division to give some sort of new framework at the start, or whether or not it was his own personal opinion. It's hard to say. But of course, the SEC is trying every different side because they know they have to try something else. Otherwise, these emails are going to be sent over to Ripple's side. Now, what does this clarification mean, though, that was specifically granted? A decision to clarify an order previously issued falls within the sound discretion of the district court. Clarifications of orders previously issued and add certainty to an implicated party's efforts to comply with the order. So it's not really a strange thing. It's just clarification. The court considers the SEC's request for clarification, bearing in mind the need to ensure that government officials are able to engage in robust deliberation as they make agency decisions which affect or millions of market participants. As discussed above, the question is whether any of the communications about edits to or comments on the draft of the speech were not just related to specific deliberations facing the agency, but comprised an essential link in those deliberations. Having reviewed the documents, I find that in general, agency staff communications about edits to the speech and the edits themselves were not part of deliberations about how to communicate agency policy. However, to the extent that there exist communications between staff discussing the speech in the context of how it implies other separate agency deliberations, not deliberations about the content of the speech. So, again, they're basically saying if some of these emails are about how to go over policy within SEC, for example, how to go over other issues within those specific emails, not about the specific contents of whatever the speech was about, the SEC may seek to redact those communications from its production. To give the SEC some guidance, comment 12 on page 6 of the speech draft in document J, which was submitted for in-camera review, is the type of communications contemplated. The SEC may redact that comment without further leave of the court. Other than any such communications, the court's January 13th order compels production of all emails related to and drafts of the speech on the SEC's privilege log. So basically, Ripple has been granted every single email. The SEC is going to try to, in that specific part, hide as many things as possible and ask or seek leave for as many different parts. But that might be justifiable in the sense that if it's not about the specific contents of this speech and they don't want to let it be in there, all right, fine, fair enough. We didn't really care about that anyway. James Fillon also talks about this as a very big win for Ripple. I think so too, because this is finally the first step into actually getting to look inside the SEC's chambers, so to speak, and to kind of see finally what they had and what everything is finally starting to walk. The SEC has identified no intervening change of controlling law or any other controlling decisions unaddressed by the court's January 13th order, which is very nice. The SEC's assertion that the speech was intended to communicate corporation finance's approach to regulating digital assets offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal views. The SEC seeks to have it both ways, but the speech was either intended to reflect agency policy or it was not. Having insisted that it reflected Hinman's personal views, the SEC cannot now reject its own position and change it up. This is a very big win for Ripple. The SEC has 14 days to file an objection to this decision to the judge, but I don't think they're going to win anything like that. So somebody asks, now time for the appeal to be filed. They have 7 days to do that, correct? He says 14 days to file an objection to District Judge Torres. Essentially an appeal. We still have a ways to go, but as of this point, I think it's juicy, juicy, juicy stuff, and I think you guys will agree with me on that one. But there's a point too. There was another email that came out, or a letter that came out. The court has granted the SEC's motion and approved the SEC's proposed redactions of the notes of the meetings between SEC employees and third parties. Not a big deal, not a heavy thing, not really anything of importance, to be honest with you. The court allowing the SEC to hide proposed redactions of the meetings between the SEC and third parties is no surprise, considering they don't want to make the government look bad. I don't know what to say about this one. It's just the SEC had meetings with people, and so we're talking here specifically about, for example, a Hinman meeting up with a law firm. For example, an SEC employee, a Hinman, a third party being, for example, a law firm. And they're saying the notes that were taken at those points, they cannot be showcased here or used in the Ripple v. SEC lawsuit. It is what it is. Or mostly just staying in the background. They're redacted, meaning the public is not getting to see anything like that. Basically hidden. But it is what it is, right? It is what it is. I'm not too worried about all of this right now. We got a big decision in front of us regarding the whole issue. Another article that calls corruption by its name and asks the very intriguing question of whether ignoring Hinman's repeated breaking of the ethic rules doesn't point to a fundamental corruption problem at the SEC. What if the SEC had only overlooked Hinman's behavior? What they're basically talking about here, and what the underlying issue is, you guys most likely understand it as well. There have been so many things that have been dug up by the XP community regarding this corruption, regarding this conflict of interest, or regarding this just absurdity. How come that has been available all this time? And whose fault is it? Who's to blame? Are we crazy for seeing all this? Or is it a really big problem within the SEC that needs to be addressed? All those things are being discussed right now, when in reality, again, even the ethics office over at the SEC, basically, they said, what you're doing is not so good. And that makes me do wonder exactly why emails like this, or at least the notes, are being redacted, when in reality you should think, put everything in the open because it's so sketchy. But that also makes you think, okay, there's a really bigger issue at stand at the background of all this. Maybe a lot of these decisions are being made deliberately to not make the SEC and the whole agency look completely corrupt. Even though I'm not saying they are, but I am saying with everything that's been found out, it does look a little bit that way. So maybe they are taking things a little bit more slowly, or they're not making decisions as heavily. The judge, for example, because of the fact that they don't want this to blow up into the mainstream of SEC corruption uncovered or something like that. Maybe that's why they're not acknowledging all these additional details. Maybe. All right, guys, that was it for today's video. Hopefully you all enjoyed it. If you did, make sure you press the like button and subscribe, and I will definitely see you guys again in another crypto video later today.